Hi, hello. My name is João Negrão, Director of the EUIPO, and you are listening to IP Fridays.
Hello, and welcome to this episode of IP Fridays. Our names are Ken Suzanne and Rolf Claessen, and this is the podcast dedicated to intellectual property. It does not matter where you are from, in-house or private practice, novice or expert. We will help you stay up to date with current topics in the fields of trademarks, patents, design and copyright, discover useful tools, and much more.
I am Rolf Claessen, and together with my co-host Ken Suzanne, I welcome you to episode 152 of our podcast IP Fridays. Today's interview guest is João Negrão, Executive Director of the EUIPO, and we talk about new patent activities at the EUIPO, the EUIPO Strategic Plan, the Design Europa Awards, the Mediation Center of the EUIPO that just opened last November, and many other very interesting things that are currently happening at the EUIPO. Before we jump into the interview, I have news for you. I just returned from the 2024 INTA annual meeting in Atlanta, where my co-host Ken Suzanne and I celebrated the 10th anniversary of this podcast IP Fridays with a nice dinner, thank you Ken, and a reception for our listeners and interview guests at the Red Phone booth in their Mafia room. The INTA was, as always, a great opportunity to meet with fellow IP practitioners and clients from all over the world. I am very grateful to the International Trademark Association to provide this opportunity. Since this is the largest gathering of IP professionals, also a lot of patent and design professionals are coming, and I actually had a lot of meetings, not even with trademark people. Now for some real news. Micron lost a patent trial in the US and must pay rival Netlist $445 million in damages. Jurors at the U.S. District Court for the Eastern District of Texas agreed that Micron infringed upon two of Netlist's patents to improve memory module capacity and performance. The German Patent Federal Court rules a patent EP 2794928B1 by 10x Genomics invalid as part of an infringement suit against NanoString. The ceremony for the European Inventor Award 2024 by the EPO will be held on 9th of July 2024 in Malta, and there will be a live stream. The USPTO is seeking nominations to fill upcoming vacancies for the Patent Public Advisory Committee, the PPAC, and the Trademark Public Advisory Committee, TPAC. Nominations must be submitted before 5th of July 2024 on the USPTO website. The USPTO also adopts the CAFC's new guidelines. Our fellow blogger Dennis Crouch has an excellent article on his blog Patently.io, What Design Patent Examiners Need to Know. Now, let's jump into the interview. Today's interview guest is João Negrão. He is the Executive Director of the EUIPO, and before that, he served as the President of the Boards of Appeal of the EUIPO. He has been with the EUIPO for 14 years after having been with INPI, the National Institute of Industrial Property of Portugal, for 9 years. Thank you very much for being here.
Thank you very much for having me, Rolf. It's a pleasure.
So the consultation phase for the EUIPO Strategic Plan 2030 closed on February 16th. What are the main topics of the strategic plan and what are the next steps?
Yeah, indeed. The EUIPO, as you probably know, has developed in an incredible way since 1994. We are now celebrating and reaching our 30th anniversary. There are many, many good things that we can think about and say about the EUIPO, but I think that we also have margin for further improvement. So this is what we are interested in fact, looking at the future and seeing in which areas we could make a difference, in fact, make a positive difference and a positive change. I think that we need, in that context, to look at the possible challenges that we have in front of us. We know that despite the EUIPO being a successful story, we have challenges like everyone else. One of them has to do with the current political, economic situation in Europe, in the world. This is generating high levels of uncertainty, I have to say, volatility about the levels of demand for trademarks, designs, and now geographical indications. This is something that for us will always be a challenge. Since we are a self-funded organization, we need to be very careful in the way we plan our activities and we implement our budget. So I would say financial sustainability, efficiency, and effectiveness will be a main topic within the new strategic plan. A second area that I would like to mention a second challenge that I would like to mention is directly related with emerging technologies. We know that artificial intelligence is having a huge impact in all areas of our life, but it also has an impact in the IP system. We have to see how we can get the best out of these new technologies to help us to work better in a smarter way, becoming also more efficient, but also help our users to apply for better applications, to receive better results in a better timeline coming out from the EUIPO. I think that if I would have to identify another challenge, this would have to be related with the fact that the IP system in Europe is expanding. We are receiving new competencies. Probably you know that we started only by being responsible for trademarks in 1994. 2003, we became responsible for designs. And recently, last year, we have also become responsible for geographical indications. And there are even more proposals coming from the Commission in different areas that are also proposing to entrust the EUIPO with new competencies. So a challenge that I see in the near future is how to implement these competencies in an excellent way here at EUIPO to ensure that we continue to provide users with quality services as we have done since 1994. And a very last challenge, I would say, everything that has to do with IP infringement. This is extremely important for users, for right holders. The fact that not only they receive their registrations from the EUIPO, but that these registrations can, of course, be held in the market, in courts. Legal certainty, predictability, and of course effective enforcement of these rights, it's something that I see as possible areas for further development, even in view of new types of technology that brings new types of trademarks and designs, virtual goods, NFTs. How are we going to ensure that we can fight infringement in a digital world, in a digital area? I don't want to be too exhaustive, but I would say these for me are clear areas that we have to look at in the next 5 years.
Yes, and thank you very much for mentioning the new competencies of the EUIPO. And I want to talk about new competency that might arrive at the EUIPO if the Council now decides so. On 27th of April 2023, the EU Commission published its proposal for regulation on standard essential patents, SEPs, and the European Parliament has voted in favor of the new regulation for standard essential patents. And previously, the EU Commission's proposal had passed the Committee on Legal Affairs under the strong influence of industry and interest groups. However, the EU Council must now approve the legislation, and the current draft suggests that the competence center would be established at the EUIPO, and in the future the EUIPO might carry out non-binding essentiality checks for standard essential patents, and front determination by mediators would be mandatory if not binding before parties can litigate in UPC countries. So far, the EUIPO did not really have much experience with patents. How do you think that the EUIPO can find enough patent experts with experience in SEPs to work for the EUIPO? And how do you see this new development?
Yeah. Look, Rolf, I think we should always follow the same methodology that we have followed since the establishment of the EUIPO in 1994. We can and we do, in fact, support the Commission and legislators within their own policy initiatives, mainly with our expertise. This is what we do. But then, of course, we are the implementing agency. We are the EU office that has to implement whatever, of course, the Commission and the legislators decide to entrust us. This is what we have done for trademarks. We have done it also for designs. And I will recall that designs, it's quite different from trademarks. And I was working in the IP office in 2002 and 2003 when the design discussions were being held in Brussels. And I recall listening also to a number of very prominent experts saying that the EUIPO could probably have difficulties in implementing these new competence because it was quite different from design. So I think it's a legitimate comment. But I think that the EUIPO also showed that we can and we have the capacity, of course, to implement what the legislators decide. This is what we will do. In fact, this is what we are doing already for the, let's say, the revised upcoming design reform. This is what we are doing also for already the competence that has been entrusted to the EUIPO in the area of geographical indications. And in case, of course, the Council and the Parliament decide to approve these proposals in the area of patents and also of course, the entrusted to the EUIPO, we will apply the same methodology to implement these new competencies. We use always a project management-based approach. So we need first to know exactly what is going to be the outcome and the outlook of these proposals in order for us to be able to draft a project that identifies the gaps and the needs so that we can, of course, act on them. I would say that currently it's still too early to know exactly what will be the final outcome. I saw yesterday part of the discussion in the Parliament, and I also saw that there were several amendments, of course, which is normal, being discussed and adopted. So I could also think that still when the discussion progresses in the Council, there will be things that might change, things that will stay, new things that will come to the proposal. That is the reason why I say it's too early for me to say how this is going to implement. First, we need to see where we are going to land with these proposals. And then, of course, we will establish a project dedicated to implement the outcome of this political will. But, of course, it's important, I think, also to say that for the EUIPO, we are not in a place to comment on policy options, obviously. This is for the Commission, this is for the Parliament, and this is for the Council. We are the ones responsible then for an effective implementation of these initiatives.
Right, of course. So far, about 95% of all licensing issues related to standard essential patents have been settled outside the courts through negotiation between the parties, and only a very small percentage went to court. The European Court of Justice has established clear guidelines for handling these cases, for example, in the decision Huawei versus ZTE in 2015. And the courts have done a great job so far. Why, in your opinion, is there a need for this extra regulation? Is it maybe solving a non-problem?
Well, as I said, of course, the policy option here, it's for the European Commission to decide, and then for the legislators to say if they agree or if they don't agree, and what they would like, of course, to change in the regulation. So honestly, I could not, of course, comment on any of the elements that you have just asked, Rolf. But I think it's important to say that we will, of course, be willing to implement whatever the legislators and the Commission decide in the end that we should implement, and we will do it in the same way as we have done for other competencies that are already implemented, like the ones that we are also now implementing in the area of geographical indications. And finally, I can say that I have full trust in the decisions that our political masters, policy masters, in this case, the European Commission, the Parliament and the Council will make. I'm sure they will be the best ones for Europe. I have no doubt.
Yes, for sure. I want to switch to a different topic. The EUIPO has launched a new mediation center in the area of IP in November last year. And mediation can be very cost efficient and quick alternative to court proceedings. What has been your experience so far? It's not a long time since November, but maybe you already have gathered experience. And what are the benefits for IP owners to choose the EUIPO over other entities that are also offering mediation in IP, such as EUIPO?
Yeah, indeed. It's true that the Mediation Center was launched last year in November, but it's also true that in the office, particularly at the boards of appeal of the office, which are our second instance, that I happen to know relatively well because I used to be president of the boards of appeal for the last almost 3 years. The boards of appeal already offer mediation and conciliation since 2011, so they have accumulated already a reasonable amount of experience and expertise in this regard. And I have to say that the results are quite positive, but limited. This is one of the reasons why we have launched a reflection last year. We have decided to expand the offer of mediation and conciliation to all the proceedings at the EUIPO, also to our first instance. And the reason for that is quite straightforward, in my view. Of course, for parties, it's very good to be able to benefit from an alternative ways to solve their disputes. And I want to say that the objective that we have here at the office is never to replace the traditional way to solve disputes. This will continue to be decisions of the boards of appeal, the decisions of our opposition and cancellation units. Mediation, conciliation needs always to be seen as something additional, complementary to those traditional decisions. But of course, if you limit ourselves to offer these types of alternative ways to solve disputes only to our second instance in the boards of appeal, what we will have in the end is that we have only few cases that could benefit from this type of solution. Because, the conflict is there already for some time when you reach the boards of appeal. For me, it's important also to offer these solutions at an early stage, in first instance, in oppositions, in cancellations, in design invalidities. And in that way, you also avoid, for many companies, and I would think that many of them might be SMEs, European SMEs, that could benefit from that in a not very costly way, in an expertise way, and also in a fast way. So that is the plan that we have for the future. By the end of this year, we wish to expand mediation and conciliation also to cancellations, and next year also to oppositions. As you know, oppositions, it's one of the main areas of work here at the EUIPO. We receive more than 20,000 oppositions per year. Some 7,000 of them receive a decision. 2/3 are solved among the parties, but 1/3 still receive a decision from the opposition unit. I think that there is margin there to offer add value to parties, to citizens, and to business. And I think that by expanding this to first instance, the results of the Mediation Center will be totally different from the ones that we have today, which are positive, but of course limited in terms of critical mass. In terms of other organizations that also offer these types of service, there are excellent mediation and arbitration center. I can think about the WIPO Arbitration Mediation Center. They also offer these types of services. They are not exactly the same as the ones that we offer here. For instance, in our case, we offer these services only on mediation, not arbitration for the moment, for ongoing procedures at the EUIPO. For instance, we don't charge any additional fee for offering these ADR solutions. If you pay, of course, our fee, you can benefit on a voluntary basis from these services. And in the end, our objective is never to compete with others, it's to cooperate. So I think that there are a number of synergies there that we can explore also with WIPO and maybe with other upcoming mediation centers, such as the UPC Arbitration Mediation Center to be established in Ljubljana and in Lisbon, that we could also benefit and could generate higher benefits for our users. So for me, it's always a question of offering users, offering parties more solutions for them, because in the end, we do this for the users, not for ourselves.
I have a follow-up question regarding this mediation center as a practitioner. At what stage do you offer these services? Do you offer them actively? Let's say in an opposition, the opposition is filed, then there will be a communication regarding the cooling off period. At what stage do you mention mediation, or do you mention this actively, or do the parties have to decide whether they want mediation?
That's a very good point. In fact, currently in the boards of appeal, we are only, of course, talking about offering it when you file an appeal. So in the moment you file an appeal, you receive information about the possibility to use mediation and conciliation. So this is done upfront, actively by the EUIPO. When we will be ready to expand it to oppositions, which of course is the big bulk of decisions that we have at first instance, we have to acknowledge what we have currently that is working well. And I will not want to disturb what works well. I want to add. I don't want to add complexity. I want to add value. I think that the cooling off period is something that works extremely well. Out of the 21 opposition positions that we receive at the office, 2/3, they are solved by the parties without any type of intervention from the side of the EUIPO. I would want very much that to continue to be the case. So I'm not going, of course, to change or disturb the way this system is working. In my view, it works very well. But as I said, there is another third that still receives a decision where I think that we can add value by offering actively to parties this possibility. I think that it's more beneficial first to have parties benefiting from the cooling off period in those cases. So that will be always possible. And if after the cooling off period still there is no agreement in sight, this is the moment in which we can ask parties if they would like to engage on a voluntary basis, on a mediation, a conciliation, on an expert determination. That's why I've mentioned that I would like to add here. I don't want to change what works well. This is something that we discuss, of course, with parties, with users in our user group. I have to say this is the feedback, the majority of the feedback that we have received. And maybe I can also return the question to you as a practitioner, if you think that this is what we should do or not.
Yes, it sounds really interesting. Very, very nice option. And I agree that cooling off works very well, and also for me. Typically, when we monitor trademarks, we try to contact potentially two similar trademarks owners beforehand, before we file the opposition, but sometimes that doesn't work, or sometimes we receive an opposition as the receiving party. And then, of course, we try to find a solution to this. So I agree with you that disturbing the system would probably not make sense. But I would say offering this actively, this option for mediation after maybe the cooling off period was not successful, that would be really helpful, I think. Okay. Yes, I want to talk about something different, something really nice. 2024 marks the 30th anniversary of the EUIPO. What, in your opinion, have been the most important achievements of the last 30 years, and what can we expect to come?
That, I think, it's the question that we are all posing ourselves. But in fact, we are in a special moment, obviously. We celebrate our 30th anniversary. We are in a transition year because we are now coming to the end of our current strategic plan. We are launching already the foundations for the upcoming strategy with the consultation. We had a wide consultation in which we have received more than 2,000 answers to specific questions that we pose to all our stakeholders and the public at large. And as I said also in the beginning, for me, it's clear that EUIPO, it's clear a success story. We started in Alicante with an office with around 10 staff members. Currently, we have 1,200. I think that the most important and impactful thing that EUIPO did throughout this year, in fact, for me, was to provide effective protection for the results of the investments made by citizens, by business in innovation. By doing that, we have protected almost 5 million trademarks and designs throughout these last 30 years. That, for me, is the biggest impact that I can think about when I think about the creation of the EUIPO. As we have already discussed, we are going to receive new competencies. We know that geographical indications have already been entrusted to the EUIPO. We will start, of course, implementing them. But I think that apart, of course, from registering IP rights, trademarks, designs, geographical indications, the EUIPO has diversified very much its range of operation. One of the areas in which we have been able to expand is in the area of IP infringement. You probably know that in 2012, the EUIPO received the observatory, the EU Observatory on the fight against counterfeiting here. in the office, and I have to say the observatory for me made a huge difference in this system. Produced hundreds of studies, produced common tools that are currently used by enforcement authorities, police, customs, so on and so forth. Provided also a platform for discussion and coordination between the different enforcement authorities in the member states of the European Union. And in fact, I have to say that made, in my view, a big difference, because it's important, of course, to register and to protect the results of innovation through IP rights, no doubt, but that is not enough. You need also to ensure that these rights are enforced, because otherwise they are just a piece of paper. And this is the contribution that the EUIPO and the observatory was able to make also in this context. I have to say that the operation of the EUIPO expanded also in other areas. For instance, in the area of cooperation. We have also by law received the competence to bring more convergence to the IP system. Because, one thing, first we have to acknowledge that in Europe, I think that we have a very unique system in terms of trademarks and designs, because we have an EU system, but then we have still national systems. This was the option of the legislator. Again, another option could have been not to have national systems, but the option was to have these two levels. So it's important that these two levels work together. They are convergent, and that users can benefit from both in the best possible way. It's not for me to say which system you should go. It's for the companies, for citizens to decide strategically where you want to go. But it's my task by law to ensure that if you come here to the EUIPO or if you go to a national system, you receive a consistent user experience. You receive a consistent service, a service that has high quality, and that by implementing a common law, the regulation and the directive, you don't receive in practice different decisions by different organizations. Of course, we are talking about subjective areas of law. There are always specificities in cases, that we know that. And case law is not written in stone. It's, of course, developing, and it should develop. But I think that there is, to a very large extent, margin for us and the national IP offices in the European Union to converge in terms of the practice, in the terms of the way we apply the law. Because the fact that we have an harmonized law doesn't mean that we apply it in the same way. Now we are applying the law in many, many areas of practice in a consistent way. I think that this is extremely beneficial for parties, for users. Why? Because it reduces uncertainty. It reduces, of course, legal costs, and ensures, of course, the high value, the quality of the decisions that are made by the EUIPO and by national offices. We also have by law a competence to cooperate internationally, externally, beyond the borders of the European Union. And the reason why we do that is quite straightforward. We do that in support of European business that are looking for making business in those regions. If we can converge the IP systems of those regions with the IP system in Europe, when a European company goes to these regions, they are confronted with a robust, solid IP system that resembles the European system. This is an element of predictability and legal certainty, where the EUIPO is also supporting the globalization and internationalization of European companies. Maybe another area where we are being active by law, we have the observatory regulation that gives us competence in all IP rights. In the area of copyrights, we have also been entrusted with specific tasks, the creation of an orphan works database that the EUIPO created some years ago. And more recently, in 2019, we have created a portal for out-of-commerce works. This is a portal that will have hundreds of millions of works that will be also available to everybody in Europe, but also beyond Europe. And I think that illustrates well that the EUIPO is not only a registration office today. It is first and foremost a registration office, but it's much more than that. We support and we try to support citizens and business in Europe from these different perspectives. If I have to think about impact, I think I would think about those things.
Yes, that's very interesting to hear, and an important thought that you're not only a registration authority, but so much more, for example, with enforcing the IP rights. And Before in this interview, you have already mentioned that you have taken over the competence for geographical indications for craft and industrial products. What is changing for IP owners by this move?
I think that's a very interesting initiative in my view, coming from the Commission with the support of the legislators. I think it will give us also in Europe the possibility for producers, for regions in Europe that are also extremely relevant to receive and to benefit from the protection for their local products. This is extremely interesting because it does not only protect them, but also recognizes the value, the quality of these products with a new type of IP rights that did not exist at EU level. Some member states of the EU have and still have national systems for protection of craft and industrial geographical indications, but you never had the possibility to have this protection at European level. This is extremely important, in my view, to connect with local communities. Local communities, local producers that are responsible for the fixation of population in these regions, for the creation of jobs in these regions, for the creation of GDP in these regions, and using these products and selling and exporting these products under strong protection with a strong recognition of quality that is important not only for the EU, but for the regions of the European Union. So for me, I think this is an extremely positive initiative that will benefit many, I hope, small producers in Europe, and for which, of course, the EUIPO is very happy to be being eligible as the implementing agency in this regard. We are already implementing this system. The system needs to be up and running by December 2025. So we are taking steps already, very clear steps, in the creation of a geographical indication register, a database. We will create an advisory board because there are also a large number of new users that we will have to interact with. These are not the trademark or design traditional users. So we are taking steps already to make the system functional, to be able on the 1st of December of 2025 to receive the first geographical indications applications here at EUIPO. I see also maybe another interesting connection in that regard is that this type of IP rights connects very well with cultural and historical heritage, something for which Europe is quite also a unique continent in the world. So again, I think that we have the possibility to connect with communities, local population, small producers through this type of IP rights, and also have impact at a more regional and small level, because sometimes impact needs also to be focused on other things that only critical mass. And I think this is a good example of it.
Yes. I wanted to also talk about your international corporations. The EUIPO expands the international cooperation with new cooperation partners such as Ukraine, the Republic of Moldova, or Georgia recently. How do IP owners profit from these corporations?
Indeed, one of the areas, as I mentioned, of work of the EUIPO is to cooperate internationally, of course, trying also to contribute for further harmonization of the IP system at global level. And in that area, we are the implementing agency for EU-funded programs on behalf of the European Commission. In fact, we are currently already implementing several of these programs around the world. To give you some examples, we have a program in China. Of course, China is a massive market that is extremely relevant for Europe. We have a program in Africa for the 54 countries of Africa. Have a program in Latin America for the 21 countries of Latin America, another one in the Caribbean. And now we will have a program in cooperation with DG NEAR for these 3 countries. Of course, these 3 countries are countries that are now candidates for accession to the European Union. So there are a number of initiatives from the European Union towards approximating these countries to our own reality. In the area of IP, the European Commission selected the EUIPO to be the implementing agency also for this country, with the aim, again, of transforming the IP systems in these countries and to bring them much closer to the reality that we have in the European Union, so that European business, European citizens that wish to make business in these three countries can also benefit from a solid, predictable, and robust IP system. In that context, of course, we will be implementing in the next 4 years a number of concrete activities. These activities, of course, cover a different range of areas: training, clearly, the judiciary, courts, in this case, harmonization of laws, harmonization of practice, building common tools that, of course, users can use electronically to file with these countries, and so on and so forth. So I see the benefit for users in a very direct and clear and obvious way. It's much, much easier if you want to protect your IP rights in these countries, if you have a system that is similar to the one that we have in the European Union. This is what we will aim at in the next 4 years, and hopefully bring them closer to a possible also accession in terms of IP rights, obviously, to the European Union. But I have to say, Rolf, in that regard, that I am personally, I'm very engaged in cooperation with these countries. I have been in Ukraine last year. I have seen how professional the colleagues there are, how they continue on working despite the huge difficulty that they are, of course, suffering and living. And from our side, we will do whatever we can, of course, to help them to improve further.
Great to hear that you actually visited the Ukraine yourself, and that's really impressive to hear. Yes.
It was an incredible experience, I have to say, also from a personal point of view.
Yes, I imagine. João, let's talk about designs. The EUIPO has been managing design since 2003, as you already mentioned, and organizes an award event now, the Design Europe Awards, to promote talent and innovation in the field of design. What are the categories of awards and what are the criteria?
Design, in fact, it's an area that I'm very, very much interested in developing. It's compared with trademarks, it has always been in the past, not at the same level in terms of the level of usage of the design system as we can observe for the trademark area. So there is a big effort on the side of the EUIPO and national IP offices to promote this system. I see already an increase, an improvement in the level of usage of the design system. Last year, we had an increase of almost 7% of design applications here at the office, which I think tells me that these promotion initiatives, they are producing also positive results. The Design Europe Awards that you have mentioned is a very good example of it. Why? Because it recognizes also designers in Europe from their excellent work. The work that they do, in fact, is remarkable, and we want to celebrate that with them. I have decided already to organize these events and these awards on an annual basis. Before it was every 2 years, so we are going to organize it on an annual basis. This year will take place in Riga, in Latvia, also a very, very design-oriented city with a number of very interesting initiatives in this area. So in September, of course, I hope that this is an hybrid event. I hope that I'm not saying something that is not correct, but if you have the possibility also to follow it, I would highly recommend it. We have a number of categories, in fact, that we try to recognize in this award. One, it's an industry category that, of course, recognizes medium-sized industry and companies in this regard. We have also an entrepreneur and small-size companies. Of course, this is an important segment in Europe, extremely important. The great majority of our companies are SMEs. We have a Lifetime Achievement Award that recognizes and celebrates, of course, designers that had a big impact, of course, in the design area in this regard. So this is something also very interesting. And for the first time this year, we will have a new category that is going to recognize also young designers, so the next generation of designers, because this is one of the segments that I'm very, very much interested in working with. Youngsters, they are crucial, in my view, also for the IP system, because as we know, they are the consumers of today. I have to say I have two sons and see them, of course, buying many products, but I never saw them in a shop. So they consume in a different way, online and so on and so forth. It's very important for us to also get closer to the younger generation, to understand what are their needs, what types of products they buy, they consume, how they consume. And then, of course, they are the entrepreneurs of tomorrow. They are the ones that will open businesses tomorrow. So it's important that the IP dimension is already there. And last but not least, I have to say that our studies in the observatory show that youngsters still have a very high level of skepticism about IP. We know that around 40% of youngsters in Europe, they buy products knowing that these are counterfeited products, but nevertheless they buy them. So we need to address this issue, not from a repression point of view from the side of the EUIPO, certainly, but from a more educational, pedagogic point of view. So I'm very, very interested, not only in the context of designs, but in general in our upcoming strategy to work with 3 particular sectors in our society or segments. Sectors, SMEs, because they are the majority of our companies, but also women. Women are also underrepresented in the IP system in the European Union. To give you a very brief example, in terms of the designed applications that we receive at the EUIPO, only 24% of these designs have a woman as a designer. We think that we are losing opportunities. We are losing potential here because we know that in Europe, more or less 50% of our population are women and 50% are men. So we are also losing on potential in terms of innovation. Our innovation potential is losing. We need to take steps also to bring more women to the innovation and IP system, in my view. And I have to say that in that regard, I'm very much in lockstep with what other offices are doing. I have to say the USPTO, Cathy Vidal, took a number of very interesting initiatives that we have immediately joined in this regard. So again, these are probably areas that we will be working in the future. But in designs, this new category, I think it's going to be extremely impactful because I want youngsters to see themselves represented also when we celebrate design in the European Union.
Yes, I will post a link to the application form for this Design Europe Awards in the show notes, of course. And as the last question to you, maybe the most important question overall, what are your personal main goals for the EUIPO and for you personally maybe, but also for the EUIPO for the next years to come?
Well, I think my personal goal now, of course, is to try to contribute to help the EUIPO to develop further, of course, to take the next step in terms of our strategic cycle, to put together a strategic plan that can ensure that the EUIPO will continue to play a relevant role within the IP and innovation system. What I can bring, it's my experience, of course, from working in different organizations at national level. As you have mentioned, I worked in the IP office. I worked also in the foreign office. I worked at the EUIPO. I worked in the EUIPO practically in all areas because I've been here head of cabinet. I've been director for legal and international affairs for 10 years. I've been president of the boards of appeal. So my goal more, to be honest, now in my last years of my professional career is to try to use this experience for the benefit of the office. But of course, I will not do that alone. We have many, many good colleagues here in the EUIPO, but also many, many good colleagues and talents in the system, in national offices, in user associations, in international organizations. I would like to bring all of this talent together and try to make a difference, to have positive change factored in the IP system, and at the end of the 5 years, again, can show impact. What have we done to improve the life of all the ones that want to protect the results of the investments in innovation? If we can show that, I will be a happy man.
Thank you so much for the great interview and for your time. I am very impressed. And thank you so much for being on IP Fridays.
Thank you very much, Rolf. Thanks for having me. It was a pleasure.
Thank you.
That's it for this episode. If you liked what you heard, please show us your love by visiting ipfridays.com/love and tweet a link to this show. We would be so grateful if you would do that. It would help us out to get the word out. Also, please subscribe to our podcast at ipfridays.com or on iTunes or Stitcher.com. If you have a question or want to be featured in one of the upcoming episodes, please send us your feedback at ipfridays.com/feedback. Also, please leave us a review on iTunes. You can go to ipfridays.com/iTunes, and it will take you right to the correct page on iTunes. If you want to get mentioned on this podcast or even have comments within the next episode, please leave us your voicemail at ipfridays.com/voicemail. You have been listening to an episode of IP Fridays. The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by their respective law firms. None of the content should be considered legal advice. The IP Fridays podcast should not be construed as legal advice or legal opinion on any specific facts or circumstances. The contents of this podcast are intended for general informational purposes only, and you are urged to consult your own lawyer on any specific legal questions. As always, consult a lawyer or patent or trademark attorney. Copyright 2014, all rights reserved.